I'm glad you brought up the issue of constitutionality, because one problem that I think we oftentimes get into, both parents and advocates and us as school board, is the parents and advocates say, well, this is a violation of rights, or this is unconstitutional, and we say, well, no, because the courts say that we can do this and we can do this, and that's kind of where the debate ends. They say this is a violation of rights, and we say, well, no, it's not, because the Supreme Court said this, and that's the end of the conversation. And there needs to be, that really needs to be sort of where the conversation begins. Okay, we've got this court case that says we can do this. That's an entirely separate question as to whether or not we should. And so that's really the place where we need to sort of proceed, and we need to know what our limitations are, both statutorily and constitutionally. But that's really sort of that's sort of the starting point, right, where we formulate our policies based around that framework. But we need to take I think a better look at not just what we can do, but what we should do. And oftentimes, even though we're not necessarily bound by the same constitutional principles that would apply outside of a school, because we know that the Constitution applies differently. Not that it doesn't apply, but it applies differently once you get inside of a school. But that doesn't mean that we shouldn't necessarily have our policies informed by some of those same constitutional principles, because not that we have to, but just it's the right thing to do. And certainly, I've discussed this with many people. I've had some brief discussions with Ms. Rose, and we're both fairly passionate about constitutional issues, and so I think we do need to know where the constitutional restraints are, but that's just sort of the beginning of the conversation.
I never said that we're doing prior notice. We're not notifying them. There's no secret here. We don't call parents before we question students if there's something going on in the school and there's a need to do that. I never said that, and we don't do that. That is not our practice. We notify parents if there's an investigation and and it's resulting in potential outcome for a student of a disciplinary nature. We certainly do notify parents in the vast majority of cases, but it doesn't take place before we talk to the student. Okay?
Sure. This particular issue is probably one that I was most concerned about prior to coming on the board, and continue to be very concerned about. We hear oftentimes about the impracticality of contacting a parent, and that if we had to wait, that it would put student populations in danger, and we don't want that. So but just a couple comments on this. Number one, if the student is removed from the general student population and sitting in an office someplace by themselves, there's a limited number of circumstances in which the student population is in danger. I mean, this isn't like the show 24, right? I mean, the number of times we've had bomb plots or something in our schools, I have to imagine is fairly small. So we're not talking about things like that, where if the student is sequestered from the rest of the student population, the number of times when there still remains some sort of a threat to the student population, where there's no way that we could wait until a parent was contacted before we start talking to the student, that's got to be really, really small. But even in those cases, again, I think we can draw on constitutional law principles. The concept of exigent circumstances developed by the Supreme Court works very, very well in constitutional jurisprudence. It is, gives wide latitude when there is, some sort of immediate, time-sensitive threat. And I think we could use similar language and a similar concept in our policies to incorporate the idea of exigent circumstances for those rare instances where even though we have sequestered the student from the general student population, there still remains the possibility of some threat to the safety of one or more students. And certainly that would be a very easy thing to write into policy. We have that a ready-made principle in constitutional law that we can draw on. Conveniently, we've got a term that already has a huge, huge amount of jurisprudence dedicated to it, and so it's cut and paste. It should be very easy to construct a policy that deals with those types of circumstances. But again, I would imagine that those circumstances are going to be very, very rare once we have taken the student and set them aside. We're not saying we can't take the student out of class until we've called the parent. We're saying that we can't begin what I would call an interrogation without at least letting the parents know that we're interrogating the child. That seems to be reasonable. And I think will not be unsafe in the vast majority of circumstances.